mental harm or physical suffering or injury, or submitted them to conditions which amounted to a serious attack upon the human dignity of the prisoners at S21. Willful killing. S21 personnel willfully caused the death of at least 400 protected persons, both directly and indirectly through a variety of means. C. National crimes. As amended by the pretrial chamber decision, certain acts characterized by the judicial investigation also constitute the domestic offenses of inflicting acts of torture to obtain, under pain, information for the commission of a felony or misdemeanor and premeditated murder. These offenses are defined under Articles 500, 501, and 506 of the 1956 Cambodia Penal Code. D. Forms of responsibility. Commission. As amended by the pretrial chamber decision, Duch is not indicted for the mode of liability of commission for the domestic crime of torture. Ordering. Duch held a position of authority at S21 throughout the temporal jurisdiction of the court. From this position of authority, Duch had the ability to direct, instruct, or order his subordinates to perform any task associated with the functioning of the S21 complex. The chain of command at S21 was clearly delineated, and the roles of its staff members were rigorously defined and enforced. Orders and instructions, whether originating from Duch or his alleged superiors, were given or passed with the intent and awareness that they would be achieved and institutionalized. Orders at S21 could be implicit, explicit, broad or specific, and could be received directly or indirectly by the perpetrator. The direction provided by Duch contributed substantially to the events which took place at S21, and much of the conduct which was attempted or occurred can be described as criminals under the ECCC law and agreement. Command responsibility. As Deputy Secretary and later Secretary of S21, Duch exercised effective de jure and de facto command and control over the entire staff of S21. This authority included the capacity to issue orders concerning all operations conducted at the security complex. Throughout his tenure at S21, Duch either knew, should have known, or consciously disregarded information that demonstrated that his subordinates committed or were about to commit the acts described in this closing order. These acts can be qualified as crimes within the jurisdiction of the ECCC. By failing to take all necessary and reasonable measures to prevent or punish the acts described, Duch failed to exercise proper control over his subordinates. Planning. Duch was substantially involved in formulating or endorsing the plan to establish S21 with the knowledge that its function would be criminal in nature. Further, following S21's formation, Duch planned the specific crimes committed herein with the intention that they be carried out. Instigation. As Deputy Chairman and Chairman of S21 and also as an active CPK party member, Duch induced, encouraged, and prompted the staff at S21 to commit the crimes described in this closing order by instructing and teaching party doctrine and practice, assigning tasks, and through his presence and participation in all aspects of the security complex. His leadership and participation were clear contributing factors to the overall functioning of S21 and demonstrated an intention that the staff of S21 carry out these crimes. Aiding and abetting. Duch subordinates respected his authority, and that at nearly every level of S21's operation, he gave them practical assistance, encouragement, or moral support. These substantial contributed to the crimes described in this closing order. Further, Duch appreciated his behavior, which assist in the commission of these crimes, knew their essential elements, and was aware of the intention of the perpetrators. Part 3. Personal profession. Duch was brought before the ECCC and was charged according to his active and passive actions in Phnom Penh and in the territory of Cambodia from the 18th of April 1975 to the 6th of January 1979 in his capacity as Deputy Secretary or the Secretary of the S21, planned, instigated, ordered, and committed the following crimes: aiding and abetting the perpetrators in this crime commission and are the person who are responsible as the superior. Crimes against humanity, enslavement, imprisonment, torture, sexual abuse, and other inhuman acts. Offenses defined and punishable under Articles
អង្គឡាំជីតម្រាក់បន្តិចដែលមានបញ្ហាផ្នែកខាងបកប្រែភាសាបារាំង
We should take a break because there is a technical glitch at the front interpreting booth.
ចេញលោកដូចបរិយឡើង
The President may declare fear, continue the reading. The crimes specified and punishable under Articles 5, 29 new and 39 new of the law on the establishment of the extraordinary chambers in the courts of Cambodia for the prosecution of crimes committed during the period of democratic Cambodia. 2. Grave breaches of the Geneva Conventions of 1949. Willful killing, torture or inhumane treatment, willfully causing great suffering or serious injury to body or health, willfully depriving a prisoner of war or civilian the right of fair and regular trial, unlawful confinement of a civilian. Offences defined and punishable under Articles 6, 29 new and 39 new of the law on the establishment of the extraordinary chambers in the courts of Cambodia for the prosecution of crimes committed during the period of democratic Cambodia. 3. Violations of the 1956 Penal Code. Premeditated murder, Articles 501 and 506. Torture, Article 500. Offences defined and punishable under Articles 3 new, 29 new, and 39 new of the law on the establishment of the extraordinary chambers in the courts of Cambodia for the prosecution of crimes committed during the period of democratic Cambodia. The President.
Mr. President, I would like to address the court on behalf of the defense. And based on Rule 85 of the internal rules, the President will ensure that the defense can freely exercise its rights. We have just heard 150 paragraphs being read out from the closing order. And so the defense would like that the 10 paragraphs which appear as exculpatory information pertaining to the accused be read out. Otherwise, this reading will be purely inculpatory, and this would not constitute a fair trial. Accordingly, we request that paragraphs 162 to 171 of the closing order be read out. Thank you, Mr. President.
The President. The trial chamber accepts the request. Due to the time limit and it's a break time, the chamber declares adjournment for 15 minutes. And at 2:40, the chamber will resume. And I would like to invite all the participants and concerned parties to attend at that time. And the request submitted by the defense lawyer will be considered during the break by the bench. Thank you.
Please be seated. The President, now the court is back in session. Before our next proceedings, the trial chamber made a decision to reject the request made by lawyer Francois Roux. In his request, he asked 10 paragraphs be read out. The paragraphs which are concerned the characters of the charged person. Because there are 4 main reasons here. First, in Rule 89 bis, states that the trial chamber declares the opening of the substantive hearing and that the President shall order the greffiers to read the counts against the accused and may order the greffier to read the factual analysis in the indictment. In the second paragraph, it reads that before any accused is called for questioning, the co-prosecutors may make a brief. So the second reason is that concerning the character and the analysis of the psychology of the charged person is not part of the factual analysis or charges. 4, in the decision on the direction of the hearing from point 9.1, the trial chamber has prepared the facts and events to be put in the trial, and the trial chamber indicated that the matter concerning the character of the accused person is an event to be conducted separately and ultimately during the hearings. That's why the trial chamber tries its best to find the justice and appropriateness for conducting such proceedings. Before we continue, we would like to move to the opening statements made by the co-prosecutors. According to the time constraints, and the trial chamber would like to inquire to the co-prosecutors whether you would like to make a brief opening statements on charges in relation to Rule 89B, subparagraph 2 at this moment. You have the floor.
Co-prosecutor, thank you, the President. Your Honors, the time is over 3 p.m. now, and according to Rule 89, and with the Honor's permission, we do have 2 hours. However, if we proceed with our opening statement, it's going to take probably till 5 p.m. And I would like to request, with Your Honor's permission, if we can do it tomorrow morning. Thank you. The President, after hearing the request by the co-prosecutor concerning the time for their brief opening statement on the charges, and second, for the smooth proceeding of the trial chamber, the trial chamber grants the permission and the trial chamber decides. The proceedings today is adjourned and it will be resumed tomorrow again. And I would like the security guards to take the accused back to the detention and bring him back to the courtroom before 9 a.m. And all the concerned parties and the public who have to attend the hearing, please come before 9 a.m. for the hearing and the proceeding. Thank you.